my very distinguished colleague, Justice Ravindra Bhatt, the Learned Attorney General for India, Mr. R. Venkatramani, Mr. Manoj Mishra, President SCAORA, Mr. Snehashish Mukherjee, Devrat, Rashmi, and all the friends in the Executive Committee, distinguished advocates on record, and all the guests present here. I must share with you a couple of stories of my first interface with clients when I first became a young counsel and entered the portals of this court. I was never an advocate on record, but of course I came to this court before I shifted to Mumbai. My first client was a person from Nasik, and the advocate on record was the indomitable Mr. V.N. Ganpule. Some of the most seniors present here would know and remember Mr. Ganpule. The client made several trips to Delhi to instruct me, and then Mr. Ganpule was going to file. Every time I met him, he would only say, "I'm going to give you many more cases." I didn't realize what the import of the many more cases was. But Mr. Ganpule was very astute. He says, when a client tells you that he is going to give you many more cases, it means that there are going to be no fees in this particular case. And as sure as he anticipated, we filed the matter and got absolutely nothing in the bargain. The second experience that I had was when we appeared for a very important politician involving a case of withdrawal of prosecution under Section 321 of the CRPC. And this politician was very praiseworthy of the work which I had done as a junior. One fine day, I was staying in a very small flat in Somvihar when the politician, lo and behold, rang the bell and was at our door in the evening. The politician got a very nice sari, which he presented or she presented to my mother. So I was very thrilled that my work was so well appreciated that even my mother got a sari. When I went the next morning to the office, the senior said, "You have had it, you're not going to get any fees. This was the fee which you got." And I was so upset because I said, how can you be so unappreciative of your junior? But as it turned out, there was no fee, only the sari. I'm sure you will have better luck with your initial few clients. But I congratulate all of you, the freshly registered AORs, for your achievement. This is a very important milestone in your professional journey in the service of the Supreme Court, and I wish you many more milestones to come. As officers of the court, you must know that your journey thus far and ahead is going to be long and challenging, but also very fulfilling. And I wish you all the best in the years ahead. I look at the role of an advocate on record as crucial in every case which comes up to us. More crucial sometimes than even the senior counsel. Because the advocate on record takes the responsibility of putting name on paper, name on the pleading, and has the ultimate answerability to the court. The seniors have a very distinguished way of appearing and disappearing in cases. But the advocate on record is a constant. You are answerable not merely to the client, but you are answerable to the court. You are the first interface of the client, and you are the only interface of the court with your client. And therefore, I do believe that this institution of advocates on record is crucial to the sustenance of our own court. I hear members of the SCBA very often. I meet the members of the executive of the SCAORA very often. But when the members of SCAORA come, I find that their suggestions are completely on a different plane because they interact with the registry, they interact with the clients, they know the pulse of what is happening in the court. I just learned the other day a new phrase when I went to Section 1B, which is there are advocates who are called 1B advocates. I never knew about it. These 7 years that I've been Chief Justice, as a judge of the Supreme Court, but I now realize that there are 1B advocates. And then I also knew that there are, advocates on record who do the work of a post office. Now, what I want to tell you really is this. The future is in your hands. It will depend upon how you fashion your career. I'm not disparaging either the 1B advocates or the post office advocates. Please, I'm not like that at all. People become what they are because of the dint of social circumstances. Everybody does not have the benefit of education. Everybody does not have the basis of the good fortune to be articulate to address the Supreme Court. But everybody has to survive ultimately, and we understand that the base of the pyramid in the legal profession is very vast. As you go upwards, it starts tapering off, and then you have the iceberg at the top. So I'm not the one who will at all criticize anybody. But what I want to tell you, you are at the beginning of your careers, and you will reap as you sow. This is the time for you to make an investment in terms of your own profession, learning, spending your time watching good advocates on record perform, spending your time watching the good advocates perform in the court, watching yourself together with others, even looking at the not so good advocates who perform in the court or don't perform in the court, because you learn from the good, you learn from the not so good as well. That's what life is all about. It's a teaching experience. But I want to share with you that times have changed from, say, the 1960s, when 65, as we learned from Devrath, when the institution of the AORs was set up. SCAORA itself was established, I think, in 1985 in order to represent the concerns of lawyers practicing as AORs in the court. And SCAORA has been enormously instrumental in doing just that through litigation as well as otherwise. During the COVID-19 period, it was SCAORA who really brought to bear before the court the enormous difficulties which were being faced by members of the bar. And they really brought a sense of collaboration between the bar and the administrative side of our court. But for you young advocates on record, you cannot rest content merely with having the ability to file matters in the court. You have to look beyond that. This is only a launching pad for you. Don't rest with what you have acquired. You will have to learn new skills. The skills of negotiators, the skills of mediators, the skills of counselors, the skills of strategists. Because the law is evolving, legal practice is evolving. It's no longer what it was when I joined the profession. And if you have to survive this intensely competitive future that you are entering, you will have to constantly reskill yourself. And therefore, as we sit at the crossroads of technological changes all around us, we must learn to apply our existing knowledge in creative ways. We have the finest technological resources now at our disposal, and we are slowly opening up to it. We have eliminated the need to carry bulky files and case compilations to court. The eSCR, and now soon the digital SCR, makes decades of jurisprudence just a click of a button away. The paper books are now entirely digitized, and the new mentioning system has significantly reduced the time taken by courts to go through the matters for a day. As Socrates famously said, the more I know, the more I realize I know nothing. And honestly, every day of my work as a judge, I learn that the more I know, the more I realize so much more that there is to be learned. Both learning and unlearning and relearning are a part of our evolution as legal professionals. This learning is no longer dependent on formal institutions. With technology at our disposal, we are in a position to learn and also disseminate our learnings far and wide at the click of a button. The SCAORA lecture series is one such public resource, which reaches not only to advocates seeking to be AORs, but also to any other legal professional with as little as an internet connection. SCAORA has, in this and many other instances, led by example in adapting to technology to enhance accessibility. At the Supreme Court, we are constantly devising ways to make courts more accessible, tech-friendly, and generally people-friendly. We are certainly not alone in this endeavor. SCAORA and SCBA, the bar in general, have supported our efforts every step of the way, and allowed us to seamlessly transition to more accessible courts and processes. And I thank both SCAORA and SCBA. None of the things which we are doing could have been achieved without the immense support of SCAORA and the SCBA. They have certainly improved our systems through actionable feedback by constantly speaking to me. I take your feedback very seriously. I have received suggestions to make special arrangements for women members of SCAORA, including VCs for women AORs, tending to young children, special recognition for first-generation women lawyers, and dedicated filing counters for women AORs. Such thoughtful suggestions speak to the robustness of SCAORA as a representative body. The Supreme Court, not to mention, is an indirect beneficiary of SCAORA's forthcoming efforts in acting as the bridge between lawyers and the courts. The changes introduced by courts have ensured convenience, but we rely almost exclusively on lawyers to transform this convenience into greater access to justice. Yesterday, we were addressed by a lawyer with a hearing impairment with the help of a sign language interpreter. She was in serial number 37, so we opened the link and the interpreter was on the screen in front of me. The interpreter translated everything from 1 to 36 for the lawyer as well, not just 37. So she knew the mood of the court, whether the judges were irritable or pleasant that day. But she knew how other lawyers were also addressing the court. This, I later realized, was a first for the Supreme Court. It was a heartening feature to know that it was a first, but I must say that it was sobering for me to see how long it took us as a system to make this happen in the history of our court. It should have happened long back. Since institutions often have the advantage of resources that individuals do not have, they must shoulder greater responsibility as well. We must also defer to the first-hand experiences of lawyers. Just last year in December, we constituted a committee to audit the Supreme Court's technological accessibility, which Justice Ravindra Bhatt is chairing, and we were just having a very engaging conversation this morning over coffee, and assess the nature and extent of problems faced by litigants. It is a step in the direction of recognizing the barriers to access which should not stand in the way of worthy litigation. Our reform should not only stop at institutions, which must also identify and persistently challenge our own biases. In choosing our causes, we must ask ourselves if our choices enhance inclusiveness or undercut inclusivity. This should be the litmus test for our professional decision-making. As argumentative individuals, we may not always agree on our means, especially we are in an adversarial profession. But we must not. But we are absolutely united in our goals, which is to promote more transparent and inclusive institutions. As long as our divergent means converge into a common goal, I see these disagreements as a sign of healthy institutional arrangement. I am certain that through collaboration we will certainly iron out finer details as we always have. In a lighter vein, I do believe that the fees which we charge as professionals is partially a function of supply and demand. With 260 more AORs having joined the group, I do believe that the fees will even out a little bit. But irrespective of fees, just as I took those 2 clients up who never paid me a farthing, but I got all the experience of life from them, not to speak about the experiences of the profession. So I would conclude by saying that there's an enormous field of challenge, of potential, of opportunity ahead for all of you. You're not just advocates on record of any court in the country, but of the Supreme Court of the nation. And as advocates on record in the Supreme Court, you have a special responsibility. You have a special responsibility to bear the traditions of the court, understand the traditions of the court, understand what people before you have done. Talk to some of the older advocates on record. Many of them may be now in the twilight of their careers. I was so delighted to see one of them appearing before me today in the court. And though we couldn't do anything in the matter, I could see all the members of the bar in the first and second row, smiling at that very senior lawyer who was appearing before me. They were so happy that that lawyer, even at that age, had returned back to the court for that occasional appearance. So we heard that lawyer out. You cannot do justice based on who the lawyer is, but you can certainly give a civil hearing to everyone at the bar, which is what I try and do. I take your leave with the hope that our justice delivery mechanisms will be enriched by our industry as officers of the court. Remember, above all, you are officers of the court. You are an extended arm of the court. And we depend upon advocates on record a great deal to do what is right and to show us the path to what is right. And in that expectation that in the course of prospering, in the course of succeeding, in the course of laying down a good future for yourself, you will also have due regard to your responsibilities to the court as the institution and for the common citizens for whom you will appear in innumerable cases, as I do hope you will. Thank you very much.